The federal courthouse hearing room fell silent as Judge Amy Coney Barrett's gavel echoed through the chamber with commanding authority, her steely gaze fixed upon White House Press Secretary Karoline Leavitt, who stood calmly at the defendant's table, facing the federal judge who held the power to end her career with a single ruling. At just 27 years old, Leavitt was about to become the first White House official in modern history to face federal sanctions for criticizing immigration court procedures during official press briefings. "Miss Leavitt," Barrett began, her voice cutting through the tension like steel, "your reckless public statements about immigration court operations have crossed the line from policy criticism into dangerous interference with federal judicial proceedings. You stand in direct violation of federal statutes prohibiting executive branch interference with ongoing immigration cases." The packed gallery of immigration attorneys, civil rights advocates, and government officials held their breath as Barrett continued her devastating pronouncement. "You have 72 hours to issue a complete retraction of your statements and cease all commentary on immigration court matters, or face immediate federal sanctions that will bar you from any future government service." Instead of the expected submission, Leavitt calmly opened her leather briefcase and withdrew a comprehensive legal analysis. "Judge Barrett," she replied, her voice steady despite the enormous pressure, "I've prepared detailed documentation that will demonstrate not only why my statements are constitutionally protected, but why they expose systematic violations of due process that demand immediate executive oversight. What happened next would shock the federal judiciary, transform immigration law discourse, and prove that expertise can emerge from the most unexpected sources. Before we reveal how Karoline Leavitt's hidden immigration law expertise completely dismantled Judge Barrett's sanctions threat, make sure you subscribe and hit that notification bell, because what you're about to witness will change everything you thought you knew about immigration courts and constitutional authority. Judge Amy Coney Barrett had been specially appointed to oversee this unprecedented hearing due to her extensive background in constitutional law and federal court procedures. At 52, she had built a reputation as one of the most formidable legal minds in America. Her sharp intellect and unwavering commitment to judicial authority earning respect across the political spectrum. Barrett's experience and deep knowledge of immigration law made her the natural choice to address what many viewed as unprecedented executive overreach into judicial territory. Karoline Leavitt's journey to this moment had been shaped by experiences that few in Washington knew about. While her public profile showed a rapid rise through Republican politics, her private academic pursuits told a different story. During her undergraduate years, Leavitt had worked summers at a nonprofit legal clinic specializing in asylum cases, where she had witnessed firsthand the systematic problems plaguing immigration courts across America. What made her criticism so threatening was its precision. Unlike typical political attacks, Leavitt's statements had cited specific case numbers, procedural violations, and statistical patterns that revealed deep institutional problems. Her background in both political communication and immigration casework had given her a unique perspective, combining policy expertise with practical legal knowledge. The confrontation had exploded 3 weeks earlier when Leavitt stepped to the White House podium for what was supposed to be a routine press briefing. Instead, she had delivered a methodical dissection of immigration court operations that would send shockwaves through the federal judiciary. The American people deserve to know that our immigration court system is failing to meet basic standards of due process and judicial fairness, Leavitt had declared. Recent analysis reveals systematic patterns of procedural violations, inadequate legal representation, and rushed proceedings that deny migrants their constitutional rights to fair hearings. Her next statement had triggered the judicial response. Judge Barrett's recent rulings have consistently ignored established precedent on asylum procedures, creating a pattern of bias that violates federal judicial standards. Her decisions in cases like Hernandez v. DHS and Martinez v. ICE demonstrate systematic disregard for evidence and legal procedure that demands immediate oversight. The press room had erupted as reporters realized they were witnessing something unprecedented. Within hours, her detailed accusations had been confirmed by multiple legal organizations, creating a firestorm about judicial accountability and executive oversight. Barrett's response had been swift and furious. In a rare public statement, she had denounced Leavitt's comments as reckless interference with judicial independence and demanded immediate sanctions. The legal establishment had split dramatically. The American Immigration Lawyers Association praised Leavitt's courage, while the Federal Judges Association condemned her statements as unprecedented attacks on judicial independence. As the hearing began that morning, the stakes could not have been higher. If Barrett succeeded in sanctioning Leavitt, it would establish precedent that executive officials could face career-ending penalties for criticizing court operations. If Leavitt prevailed, it would open the door for unprecedented executive oversight of judicial procedures. Barrett had entered confident in her authority and legal reasoning. Immigration law was her specialty, and she had never encountered a political operative who could match her legal knowledge. What she didn't know was that the young woman standing before her had spent years studying the very cases and procedures that Barrett assumed only judges understood. Miss Leavitt, Barrett began with judicial authority. Your statements 3 weeks ago exceeded the bounds of legitimate policy criticism and entered the realm of judicial interference. You specifically attacked individual judges' decisions in ongoing cases, cited confidential court data, and made accusations of bias that threatened the independence of federal courts. She leaned forward, her voice carrying the weight of decades of legal experience. Your role as press secretary, while important for administration communication, does not qualify you to evaluate complex immigration law procedures or critique individual judicial decisions. These statements demonstrate a fundamental misunderstanding of both legal procedure and constitutional separation of powers. Leavitt remained composed despite the withering assessment of her qualifications. Judge Barrett, I appreciate your concern for judicial independence, which is indeed a cornerstone of our constitutional system. However, before this hearing proceeds with sanctions, I believe it's essential to examine the factual accuracy of my statements and the constitutional framework that protects executive oversight of judicial operations. She referenced her prepared materials with practiced precision. I'd like to begin by addressing the specific immigration cases I referenced and the documented procedural violations they contain, then examine the legal precedent that not only protects but requires executive officials to identify systematic judicial failures when they threaten constitutional rights. Barrett's expression revealed surprise at Leavitt's systematic approach. Most political figures facing judicial sanctions would apologize and retreat. Instead, Leavitt appeared prepared for substantive legal argument. Miss Leavitt, This is not a policy debate. The issue is your inappropriate interference with ongoing judicial proceedings. I understand that distinction, Judge Barrett, Leavitt replied respectfully, which is why I'd like to direct your attention to Youngstown Sheet and Tube Company versus Sawyer, where the court established that executive oversight of judicial operations is not only permitted but required when systematic constitutional violations are occurring. The reference to a foundational case caused a stir in the courtroom. Immigration attorneys leaned forward as they recognized Leavitt was building a sophisticated constitutional defense. In Youngstown, Leavitt continued, the court emphasized that while judicial independence must be protected, it cannot shield systematic violations of constitutional rights from legitimate executive oversight. The executive branch has not only the authority but the constitutional obligation to identify and address patterns of due process violations in federal courts. She turned to another section of her materials. More specifically, in INS versus St. Cyr, the Supreme Court held that immigration proceedings, while administrative in nature, must comply with fundamental due process requirements that are subject to executive branch oversight and enforcement. Barrett interrupted with visible skepticism. Miss Leavitt, those cases address broad constitutional principles, not specific criticism of individual judges' decisions in ongoing cases. Your statements went far beyond policy oversight to personal attacks on judicial competence and integrity. It was precisely the opening Leavitt had anticipated. Judge Barrett, I appreciate that distinction, which is why I'd like to examine the specific language I used and its legal foundation. She produced transcripts of her original press briefing with case citations highlighted. I stated that Judge Barrett's recent rulings demonstrate systematic disregard for evidence and legal procedure. This characterizes a pattern of judicial behavior documented in court records, not personal competence. In Caperton versus A.T. Massey Cole, the Supreme Court established that patterns of judicial bias, when supported by documentary evidence, are subject to legitimate public scrutiny and executive oversight. Furthermore, Leavitt continued with growing confidence, in Hernandez versus DHS, the case I specifically referenced, the court record shows asylum seekers were given an average of 3.2 minutes to present their cases before being denied. This violates established precedent requiring adequate time for testimony and evidence presentation. She displayed documented statistics that caused murmurs throughout the courtroom. In Martinez versus ICE, the court record indicates that 89% of deportation orders were issued without legal representation present, violating due process standards established in Gideon versus Wainwright. Barrett's expression had shifted from confident authority to grudging engagement with Leavitt's systematic presentation of legal evidence. Miss Leavitt, while your research appears thorough, executive officials cannot publicly attack judicial decisions based on their interpretation of case records and statistics. Judge Barrett, that's exactly why I'd like to address the constitutional framework that not only permits but requires such oversight, Leavitt responded. In Marbury versus Madison, Chief Justice Marshall established that constitutional violations by any branch of government are subject to oversight and correction by coordinate branches. She referenced another section, more directly applicable in Plout versus Spendthrift Farm, The Supreme Court held that while Article 3 protects judicial independence, it does not immunize systematic constitutional violations from executive branch identification and remedy. The dynamic in the courtroom had transformed completely. What began as a disciplinary hearing had evolved into a sophisticated constitutional law seminar, with the youngest person in the room demonstrating mastery of immigration law precedent that was clearly surprising even experienced attorneys. Barrett attempted to regain control of the proceeding. "Miss Leavitt, constitutional principles aside, your statements crossed professional boundaries by personally attacking individual judges rather than addressing systemic policy concerns." Leavitt nodded respectfully before delivering what would become her most powerful argument. "Judge Barrett, I appreciate that concern, which is why I'd like to examine the historical precedent for executive criticism of individual judicial performance when constitutional violations are documented." She turned to a comprehensive section of her legal analysis. President Lincoln publicly criticized specific judges by name for their roles in Dred Scott versus Sanford, stating that judicial decisions must be subject to democratic oversight when they violate fundamental constitutional principles. President Roosevelt identified specific judges whose decisions threatened constitutional governance during the New Deal era. More recently, Leavitt continued building momentum. President Obama publicly criticized Chief Justice Roberts by name during his State of the Union address for the Citizens United decision. President Trump identified specific judges whose immigration rulings he viewed as constitutionally problematic. Neither faced sanctions for their criticism of individual judicial performance. She paused for effect. "The difference is that my statements were supported by documented evidence of procedural violations rather than political disagreement with outcomes. This makes them not personal attacks, but evidence-based accountability measures protected by both constitutional precedent and executive oversight authority." Barrett's composure was visibly strained as she struggled to address Leavitt's systematic constitutional defense. "Miss Leavitt, presidents have different constitutional authority than appointed officials. Your position as press secretary creates different legal standards for public criticism of courts." "Judge Barrett, I appreciate that distinction," Leavitt replied, "which is why I'd like to address the specific constitutional authority of executive branch officials to identify judicial violations." She referenced Supreme Court precedent with remarkable precision. In Myers v. United States, the Supreme Court established that executive branch officials acting within their constitutional duties have broad authority to identify and address violations of federal law and constitutional procedure. "My role as press secretary includes informing the public about government operations that affect constitutional rights," she continued with devastating legal logic. In Youngstown, the court specifically noted that executive officials not only can but must identify systematic violations of constitutional procedure when they threaten democratic governance. Immigration court proceedings that deny due process violate constitutional requirements that executive officials are sworn to protect and enforce. The most powerful moment came when Leavitt addressed the specific cases she had cited. "Judge Barrett, since you've questioned my qualifications to evaluate immigration procedures, I'd like to address my background in this area." She produced documentation that would transform the entire proceeding. "During my undergraduate years, I worked for 3 summers at the Rocky Mountain Immigrant Advocacy Network, where I assisted attorneys with asylum cases and witnessed firsthand the procedural violations I described in my press briefing. I completed intensive training in immigration law procedures and maintained detailed case notes documenting systematic due process failures. The revelation caused audible reactions as observers realized that Leavitt's criticism had been based on direct professional experience rather than political rhetoric. After graduation, I continued working with immigration attorneys as a volunteer while building my political career. My statements were based on 5 years of hands-on experience with the very court procedures I criticized. She displayed professional certifications that few had known existed. I hold certification in immigration law procedures from the American Immigration Lawyers Association. My criticism of court operations was based on professional legal knowledge, not political opinion. Barrett, who had entered the hearing confident in her authority to discipline an unqualified political operative, now found herself facing someone with documented expertise in the very field she sought to protect from criticism. Miss Leavitt, while your background is more extensive than I was aware, criticism of ongoing cases still raises serious concerns about interference with judicial independence. Judge Barrett, that's exactly why I'd like to address the constitutional balance between judicial independence and democratic accountability. Leavitt responded with quiet confidence. She turned to her most comprehensive legal argument. In Ex parte McCardle, the Supreme Court established that while judicial independence must be protected, it cannot immunize systematic violations of constitutional procedure from legitimate oversight. The court specifically held that democratic governance requires accountability mechanisms for all branches of government, including the judiciary. Moreover, Leavitt continued, in Northern Pipeline Construction Co. v. Marathon Pipeline Co., the court emphasized that Article 3 protection of judicial independence exists to serve constitutional governance, not to shield individual judges from accountability when their decisions violate established legal procedure. She displayed comprehensive statistics that supported her original statements. The immigration court data I cited shows that 78% of asylum cases in the Fifth Circuit are decided in under 5 minutes, compared to the national average of 47 minutes. This systematic pattern violates due process requirements established in Matthews v. Eldridge and its immigration law applications. Barrett's expression had shifted to grudging respect as she realized the depth of Leavitt's legal preparation and professional knowledge. Miss Leavitt, while your constitutional arguments are sophisticated, this hearing must address whether your specific statements crossed legal boundaries regardless of their factual accuracy. Leavitt's response would become legendary in immigration law circles. Judge Barrett, with deep respect for your legal expertise and this court's authority, I believe that's exactly the wrong constitutional standard. She paused before delivering her most powerful constitutional argument. In New York Times v. Sullivan, the Supreme Court established that criticism of government officials, including judges, receives the highest constitutional protection when it addresses matters of public concern. Immigration court procedures that affect thousands of people annually are unquestionably matters of public concern, requiring robust, democratic debate. Furthermore, she continued, in Pickering v. Board of Education, the court held that government employees not only retain their First Amendment rights, but have enhanced protection when their speech addresses governmental operations that violate constitutional standards. My statements about immigration court failures fall directly within this protected category. She organized her materials with quiet dignity. The constitutional framework is clear. When government officials identify systematic violations of due process based on documented evidence and professional expertise, such speech receives maximum First Amendment protection because it serves the essential democratic function of governmental accountability. Barrett sat in contemplative silence for several moments, the systematic presentation of constitutional law having effectively challenged her authority to impose sanctions. The legal foundation for disciplinary action had been methodically dismantled by someone she had expected to easily overpower with judicial authority. "Miss Leavitt," Barrett said finally, her voice noticeably less authoritative than at the hearing's beginning, "your constitutional analysis is more comprehensive than anticipated. This court will need to consider the legal arguments you've presented regarding executive oversight authority and First Amendment protections for government employee speech." She glanced at her notes, clearly recognizing the strength of Leavitt's defense. Given the complexity of the constitutional issues raised, this hearing will be continued pending further legal review. You are not subject to sanctions at this time. As the hearing concluded, observers recognized they had witnessed something extraordinary. A political operative had successfully challenged federal judicial authority using sophisticated constitutional arguments supported by professional expertise that few had known existed. Within hours, immigration law experts began analyzing Leavitt's defense. Georgetown Law called it a masterclass in constitutional law, while the American Immigration Lawyers Association praised her sophisticated understanding of due process requirements. The aftermath extended far beyond the immediate legal questions. Law schools reported increased interest in immigration law courses. The case became a landmark example of how expertise could emerge from unexpected sources and how constitutional principles could protect democratic accountability. 3 months later, Judge Barrett issued a comprehensive ruling that declined to impose sanctions while establishing new guidelines for executive oversight of immigration courts. The ruling noted that Ms. Leavitt's constitutional analysis demonstrates the sophisticated legal reasoning necessary for legitimate executive oversight. 6 months after the hearing, Barrett invited Leavitt to speak at a federal judges' conference on immigration law. In her introduction, Barrett acknowledged, "Ms. Leavitt reminded us that expertise can emerge from unexpected sources, and that democratic governance is strengthened when such expertise is applied to identifying systematic failures." As Leavitt addressed the gathering of federal judges, the journey from potential sanctions to respected legal voice was complete. What had begun as an attempt to silence criticism had instead established new precedent for constitutional accountability and proven that the most effective legal minds are found in unexpected places.